we're going to start today with what I promised would be language. So before we go into too much of the midterm and start reviewing it, hello there. College athlete is the same experience as a professional athlete. I mean, beg to differ. Anyway, talk to me. We did Riley last time. We've covered search and seizure. We've covered the exclusionary rule briefly. We talked about Riley, which was issues of warrantless searches of a cell phone pursuant to a lawful arrest. So someone tell me about Lange.
There was a traffic stop.
Yes.
And the person failed to yield or pull over. The officer followed him. Was it to his home?
Yes.
And he drove into his garage
Mm-hmm.
and then insisted that him failing to yield and going into his garage warranted this garage visit.
Correct. So we have a search and seizure in a garage following a botched traffic stop. Anything else important that we're missing? Any other legally relevant facts?
The cop tried to use extreme circumstances to go in the house
Yes, he did.
for the attachment on the garage.
Yes. Anything else?
Plea or pursuant.
Yes, he was fleeing. That was the allegation that the officer made. So what we say pursuant?
Yeah, apparently they tried to stop him rather than pull over and.
Yes.
Going to stop instead.
Yep. All correct. Anything else that we're missing?
He also followed him for a few blocks before he overturned the arrest.
Correct. So the car followed the patrol car, that is, followed the car that it was attempting to stop before it ever hit the flashers, lights and flashes.
He did kind of bring it on himself, you know, by honking the horn and going by the cops like that.
Yeah,
Like
how did
that,
this get started,
just-
right? Go ahead, Lorena.
Well, he was playing loud music and had half the bus 45 times. So, and then there was like no like vehicles nearby, so I'm just and I was like, someone like myself who plays loud music, if the officer doesn't really put on his sirens or his lights, I'm just, I don't know, you don't hear much if you have music.
Yeah.
It's completely loud.
What are your initial thoughts about this traffic stop? Before you read the case, you just read the traffic stop. What are your thoughts? Dumbass? Of who? That is the officer or the man who
No,
was
the
arrested?
guy driving, I mean, I'm sorry, I'm not one to like side with prosecution at all, but I'm just like, dude, if you were fucked up, how are you gonna go by a cop and just blow your horn? And I mean, that's just stupid. Now, the cop still had no right to invade his house, but you know, I don't know, that's.
Let's say like he was, like, would it be anything illegal, like to do with these over and stuff, more than 4 times? In the public.
Don't they have certain jurisdiction over loud music, but is it past certain hours or is it just be real?
Usually that's curfew hours, which generally are considered like 10 to 4 a.m.
I thought it was like, if you could hear it within like 50 feet or something like that.
So generally every jurisdiction is gonna have different rules with respect to like what is considered like noise pollution or what is considered like interference. And it's really up to the individual officers when they get a call and they arrive on their discretion on kind of how to play it. So we have a not so smart on part of the man who got pulled over. Any other initial reactions to this traffic stop? And Lorena says, not so much on the music. Why? Why about music? I think you're onto something there. What do you think it was, Lorena? Do you think this stop was about the loud music?
No, not really.
What do you think it was? We have a word for it in law. What is it?
I don't know what the word for it is, but probably with the honking, like I can just picture riding in a car with one of the investigators that work in like immediately, I got pull this guy over right now, because he's honking at me.
We don't think this might have been a pretextual stop. What do I mean by pretextual stop, Joshua, since you said yes?
When they use based off like detail that they can see or like auditory, you know.
You're right. Yeah.
Whenever they can
what does it mean when someone does something with pretext? Go ahead, Victoria.
Didn't we talk about it before when we were talking about like. When we saw certain things with kind of like the colors people are wearing. Absolutely. The words that they're wearing. And their style is, maybe if they have tattoos, what the tattoos say.
Absolutely, those all go into what's the standard? Discuss a lot in this case, what is it?
In my words, I call it the gold standard.
And what is that?
The golden standard, meaning like, it's the written like set of standard rules that we as the people have set upon ourselves. That we have known throughout media, movies, television.
What's the legal standard though? To know if we can pull someone over. Reasonable suspicion as determined by,
The officer
correct?
discretion.
You guys named Victoria named a whole bunch of factors, what do they go to? Yes. So do we have enough information? Lorena says, I think we did. Which would make, if we don't have enough in the totality of circumstances, it would make the stop pretextual. So what do I mean by that?
It's an excuse to go look further things.
Bingo, Michaela, an excuse, it's pretextual, meaning they have another reason they're not really telling you about. Anybody else get that vibe when they were reading through the facts and language?
I don't know, that's really bizarre behavior though, to honk the horn for absolutely no reason.
Any Memphis native drivers think that it's strange behavior?
I got stopped the other day in Arlington because I cut off the van. Yeah, so.
Yeah. Arlington, yeah, who knows what happened out
Like,
there, I can't help you out, I can't help y'all outside of the 240 loop, I'm sorry. Y'all are on your own, there's a reason I don't step over that boundary. Won't catch me, not happening.
I live out there, ain't none reason to live out there.
I think one of the big things, Victoria. I agree, that's why I refuse to do that. I think one of the issues with this case, and one of the reasons that we see the outcome that we do, is that the justices are a little concerned that this stop was actually, it might have actually been pretextual. Is it super common to honk 4 times and then move? No, but does it give us, remember what's reasonable suspicion? Because remember, totality of the circumstances, we need reasonable suspicion. We need specific articulable facts, remember? So what can he articulate? That gave rise in this circumstance? The stop.
Well, is the music thing, is that like, is that a violation? Like,
So it's one of the things he says, loud
granted,
music,
the honking is weird, but it's not criminal.
right?
However, was the music a violation of the law?
Neither were violations of the law.
Okay.
So remember our thing for reasonable suspicion that a crime will take place in the near future, right? And all we have is loud music and honking. Do we have reasonable suspicion?
I don't think so.
I mean, the honking is what gets me, it's like, I can understand like, okay, so you know, next to the road, you're honking, trying to figure it out. But you also, in the same instance, say, okay, he's honking the truck to like get his attention for something as well.
Also, could the officer see inside of his car to see what he was doing inside the car? Do we have anything on the record to suggest he did? So do we know who honks the horn even? I mean, obviously, we know ex post facto that, you know, we can assume he did because there was no one else in the car, but what if there had been like, you never been in a car with a kid who just sit there and honks their horn? Or my little brother will actually do this for my sister-in-law when they drive together and someone cuts my sister-in-law off and they won't honk and get irritated, so my brother will reach across and honk on the horn for them, excuse me. So how did we know the driver for sure did it? And also neither of these things are illegal.
So it really doesn't even matter who honks the horn because it's not illegal.
Not illegal.
Maybe he was checking to see if it worked.
Yeah.
Maybe he was checking to see if it worked, right?
I wouldn't mind if I didn't accidentally hit it, like, at least once a day.
Same. John and then Josh, you had your hand.
I was just checking just because I didn't know, but it's the California vehicle code that music heard outside of 50 feet away from it is something that can be cited.
But yeah, he could have received a citation perhaps for it, but at most,
But that could have been the reason he couldn't have over and he'd been totally
in theory,
within the bounds of law.
in theory, yeah.
The only thing that really makes sense is that if people are under this, under the influence of something.
Josh, what were you gonna say?
I thought because they talked about a skill sobriety test, I thought because of the honking and allowing him, maybe he was drunk on the road, and that's why they would have went to his house and so on and so forth, but if they didn't really give me context, they didn't.
Right.
So,
Yeah,
what was the reason?
yeah. So we have a big question of essentially, what was the reason? That's really what we're left with. Is why did this stuff happen? And what does the officer try to say? Now we're getting into a little bit of what's the issue in this case. Somebody tell me what their issue was. How they phrased it.
Do accident circumstances, are they protected by the Fourth Amendment? Or are accident circumstances protected by the Fourth Amendment?
Anybody else? Thank you, Ellie. Yeah, get your yapping points. Go ahead, Andy.
Exigent circumstances qualify to a non-violent fleeing misdemeanor.
Include what was the last thing you said?
Non-violent fleeing misdemeanor.
Anybody else? Josh, go ahead. Oh, sorry. Josh, then Taylor.
I just have it is the pursuit of the suspect and they're not without a warrant constitutional violation of your.
Go ahead, Joshua.
That was pretty much it.
You sure?
Yeah.
You got all your talking points to say anyway. Go ahead, Abdullah.
Does a warrantless entry into victim's garage validate or solidify a recent case?
Anybody else want to go? Make sure everybody got their talking points as someone so brilliantly named them a few moments ago. Yapping points, excuse me, I'm so sorry. Would never want to, yeah, can you imagine if I had called them something else, how ridiculous would I sound? All right, what do you guys think? Best phrase issue. Those of you who did not give me your issue, what do you think? Joshua says 3. Okay, let's say 2.
I think a combination of 2 and 3.
2 and 3. Destiny. Anybody else? I think you're right. I think what we're mostly talking about, specifically, we're talking about exigent circumstances. So we know we're within that category of warrantless exceptions to the Fourth Amendment. We also specifically want to talk about fleeing, and we want that it's a misdemeanor. Why is this particularly important? But also because we're in pursuit, that's what exigent circumstances are traditionally conveyed to mean. Pursuit of suspect, hot pursuit. Go ahead, Victoria.
Usually when it's like a hot pursuit, it means they have like a felony.
Yes.
That's why they're being.
So when exigent circumstances, i.e. hot pursuit, was established as a warrantless exception to the rule, the assumption was that the officers knew that they had committed likely a violent felony or a felony of some kind. There was a serious reason to follow the individual. They had seen it, witnessed it, again, either a violent crime or specifically a violent felony. What is here?
A non-violent, non-felony.
Maybe a traffic ticket, right? So the Supreme Court essentially has to answer the question of whether a misdemeanor, whether police are allowed to pursue in hot pursuit as if they are for a felony, if they are for a misdemeanor. That's essentially the question. So I think agree 2 and 3, because again, exigent circumstances, the reason that is created is the pursuit of a suspect, but it has always been traditionally interpreted in the context of fleeing. So fleeing from a felony that was committed or a violent act committed. So now somebody tell me what the rule is. What did we come up with?
Can I ask a question?
Yes, you can.
Okay, and it may be a little meta, but
Love it.
technically, if you're evading, you're committing a felony. So if you weren't already committing a felony, now that you're evading, you are committing a felony. So then they can pursue you, right?
Yes, it is a very interesting way to police charge resisting and resisting. It just also depends on the specific, because there's always levels of resisting arrest. So for instance, in Missouri, there could be 2 types of felony resisting and then misdemeanor resisting. One type of felony resisting was if you knew the felony you were essentially being pulled over, stopped, or arrested for, and you continued to flee, that was felony. Another way is if you created a substantial risk of death or serious physical injury in the flight, that's always going to be a felony. So that's a car chase situation. A misdemeanor would be any other attempt to flee from police whatsoever. So it would be a misdemeanor. So that's why it's kind of very important that we know why, because in a lot of jurisdictions, if the individual knows or has reason to know, meaning they just did something in front of police and they know they're in trouble, then we typically treat it as a felony if the underlying issue is a felony. But where it is a misdemeanor or where there's any other thing and there's no harm caused, we've always treated it like a misdemeanor. So now the Supreme Court takes up this issue. First and foremost, very important thing, when was this case decided?
2021.
So this is a very recent case, which means who is not on the court for us anymore? RBG is gone. Who else is gone? As far as Fourth Amendment people. Scalia is gone. So 2 of our most prominent Fourth Amendment jurisprudence, or Fourth Amendment, I can't remember what I'm looking for. Advocates, thank you, that's a good one. Stands, that's a good one. Are no longer with us, they're deceased, no longer on the court. Instead, we have the newest member, Amy Coney Barrett, pretty much her first case she decides. What is the split on this?
It's not.
This is unanimous, so this is the second search and seizure case that we've seen with a unanimous outcome. Based on what we talked about in Riley and what we now know about in Lange, talk to me about why we think we got the exact same outcome. Like, we're gonna put aside the fact that there's like a ton of concurring opinions that, remember what are concurring opinions when it doesn't change the outcome of the case? We're just talking. Yes, just all dicta. That's just all that's all the judges and justices pointing out where this is going to be a legal issue coming up. Absolutely, this is going to be a legal issue coming up. All the justices are writing concurring opinions and signaling it because the way that we had written the standard in Lange is not super clear. So talk to me about it. How do we get to it? What are the justices saying? What's some of their legal reasoning? So we know we have exigent circumstances. And what do we know about exigent circumstances? Because I've already told you.
That this case was not one of those times where exigent circumstances apply.
Fleeing from a felony or other form of violence. That's when we've recognized exigent circumstances. We have not yet as a court ever recognized it for anything less. It's never happened before. So what does the court say about it?
It really just needs to be taken, like the exigent.
Exigent, yeah.
The circumstances
Mhm.
need to be taken on a case by case situation, and this one specifically. They don't.
And that just fleeing does not yield exigent circumstances if you have to consider the crime that they're fleeing from.
Somebody else has their hand up, Annie, and then Destiny.
I was gonna say, trustness, first of all.
Got it, love it.
With like the precedents that were stated in the case, like Stanton versus Sims, it says the law regarding warrantless entry and hot pursuit of a fleeing misdemeanor is not established, so like there's no, like it is a case by case basis, but there's also nothing established prior to justify chase, like being in hot pursuit of someone who committed a misdemeanor, and usually police wouldn't even chase misdemeanors because it's not like.
Great. That's me, go ahead.
I was just thinking more in the searches, like the same with Riley, like we did a warrantless search with the cell phone and a warrantless search like in the home. So I don't know how we're going with that, but that's what I was thinking.
Yeah, we're absolutely in the realm of generally things we don't like. We want a warrant. Why are we specifically perhaps more upset about this search than we were about the cell phone?
Your house is like so private.
This is your house. This police officer followed a man into his garage, did he not? For not pulling over for having loud music. Remember what this, go ahead, do you have your hand up?
Oh,
Yeah, go
yeah, I was gonna just add to that, it kind of says like the flight, itself is the reason for them to have a warrant for search. It's followed with like the misdemeanor or something, like in this case, it's just like a flight.
In this case, we just have flight, and flight is not enough. Where else have we heard that flight alone is not enough?
USV Santana.
I love that you're signing, okay, but what in, sorry.
Sorry, that's pretty
What is, well, fleeing can be considered a factor in what?
Totality of circumstances.
So if you just have one circumstance, have you risen to the level that you need to get, to get some exigence? To get some exigency? No, you haven't even gotten out of reasonable suspicion, you have one circumstance. And fleeing alone is not enough, flight alone is not enough. It's not gonna give you reasonable, so if we think about this and remove the car from the situation. So a guy is standing on the street, he yells loudly 5 times, and then he starts running. Yeah, he's got boombox, and then he starts running. Would we ever think it was okay for police to stop that individual, fully pat them down and or put them under arrest and search them incident to a lawful arrest? Never in a million years. Never in a million years. So remember what was the court concerned about in Riley? Remember, it's a unanimous court. A lot of what we would typically consider to be conservative judges were writing in on the opinion. Granted, they have some takes that they go in different directions, but generally they were all of the no, this is not okay. Why? Why do the conservative justices still not want this?
Because they don't want their phone searched without a warrant.
Right. In Riley, they didn't want their home searched without a warrant. What about this case? They don't want you coming around. Do they want people coming into their garage just because they forgot to see the lights? Now remember, they're all old as hell. They're all wearing bifocals. Some of them even have hearing aids. Clarence Thomas falls asleep during every single oral argument. Great, it's fun to watch. Just love it. He never speaks and falls asleep during every oral argument, but yeah, he's a justice. What if they missed and didn't hear the lights and sirens pull them over and they just happened to pull over or just stop in their home?
They're probably going to jail.
Absolutely.
No,
Does
they
it,
wouldn't.
does it seem like small government for the police to be able to follow you into your home after you've stopped your vehicle? No, and remember, even though conservative individual or conservative justices have certain jurisprudence about, or that we see, or we saw along the lines of like protest and free speech and thinking kids don't have rights. And all of those things are very interesting, but what was still true of the founders?
They wanted, what's it, not federalism?
They wanted not federalism.
What is that called?
Yes.
Anti-federalism? I can't remember.
Yes, they were anti-federalist. They did not want a strong federal government. So they didn't want a strong national police presence. Does this, if we had okayed this situation and said, yes, this was constitutional, does that seem like small government to you?
No.
Does it seem like protecting your interests or your persons, places, or things? What does it seem like to you?
Dictatorship.
Or police state? What's the Third Amendment again? The one we don't talk about. Forcing you to have soldiers in your home? Would this be entirely different than saying you have to allow them to come into your home if they followed you legitimately from wherever you were making loud noise? No. So don't ever get away from, especially when we're talking about which justices do or do not align with a specific kind of interpretation, never get away from the fact that at the court, we're not talking about Democrat versus Republican. So like a lot of times people might look at Lane and think, democratically, they're gonna want this right to be protected, and Republicans are gonna want it because they're in favor of police presence. But we know even the Republican appointed justices didn't want this, and that is because jurisprudence in the Supreme Court, although we do sometimes, categorize it as liberal or conservative, that interpretation has to do with the actual, how far we are able to stretch the words. So, I see you, Victoria, give me just a second. So could we stretch the Fourth Amendment the way that it is written to cover this circumstance?
No.
Using the founder's words?
No way.
Because what does the Fourth Amendment say?
Unlawful seizure.
No exceptions. No exceptions. Except the Supreme Court has made several, but
No exceptions,
no exceptions except the one the Supreme Court's made, right? But that was the original intent. And so the individuals who represent a conservative viewpoint still want to represent that original intent in the four corners of the document. The Fourth Amendment would not have permitted this. The soldiers from Britain or early American soldiers wouldn't have been able, or early American police forces wouldn't have been able to come into someone's home following an incident like this, so they don't want it. Does everybody see how we get that outcome? And how we're getting these 9-0 decisions in cases where you might otherwise think that certain justices may lean a certain way? Is everybody understanding that? Gracie, go ahead.
It was saying that this, type of case, and then it's just like, the whole thing is kind of common law from the Constitution.
Yes.
Yes.
Yes, this is all judge-made law. All that they're discussing is judge-made law. Because we have one Fourth Amendment, and that said, no, this wasn't admitted, this wasn't, this behavior that the police engaged in wouldn't have been permitted at all. And the Supreme Court said, well, we've said it was in certain situations before, and here's why it doesn't apply to those situations. But then they go on to say, who said it case by case? Whoever said that? Yes, thank you, Michaela. That is one of the biggest things that we take away from Lange, is that the Supreme Court is really not going to issue a broad or a consistent or a always applies test with respect to misdemeanors. And they say, no, we're not going to. So they actually reject what the defense wanted, which was the defense wanted to make a rule that necessarily flight from a misdemeanor was not enough to justify a warrantless entry. And the Supreme Court refuses to do so. And instead they say this should always be done on a case-by-case basis. Now, we know that the law is supposed to help us inform and help us predict what we're supposed to be able to do. How does Lange help police or prosecutors know what they should or should not do, or whether or not a case that comes in front of them is going to be upheld using the Lange standard? How would a prosecutor or a police officer in such a situation know that they're not outside of the Fourth Amendment if we're doing a case-by-case basis? So Lange says, with respect to the misdemeanor and flight therefrom, we're not going to make a, what we call in law school, a bright line rule, meaning very firm. Here's the rule, that's in it, this is out of it, there's the line. And they say, no, we're not going to draw that line. We're not going to draw it. We're going to instead say it should be done on a case-by-case basis. Again, going back to the totality of circumstances. But we know one of the goals for all Supreme Court law is generally the interpretation of the Constitution that is consistent, applicable, and can be used so that other individuals, no matter the jurisdiction, whether you're in a district court in California or whether you're in an appellate court in Tennessee, they know how the Supreme Court is going to apply the law. How does Lange help them?
If it's case by case, it wouldn't help them, would it?
Yeah, you're exactly right. Doesn't help anybody. So why did the Supreme Court agree to take this case? Anybody want to guess? What happened this year?
The overturning. No.
Roe came right after that, but
What race were these people?
Biden had come into office. Who died this year? I mean, yeah, a lot of people died. Sorry. What significantly national televised event? There we go.
So the Black Lives Movement is that?
I mean, I think that might have had something to do with it. Black Lives Matter movement was in full swing at that time. Harken back to the first cases that we read on the protest cases. If they were playing their music too loud, or if they didn't stop on the way home, or think of what happened in the George Floyd case. It was for passing a bad check, was it not? That was why he was originally stopped. Do you know what that is? It's a misdemeanor. So why might the justices have wanted to take up this case and then still give us a pretty shitty case by case ruling?
To avoid polarity.
Lorena and to avoid polarity, to cover their own ass, publicity. Lots of reasons to take this case at this time. Politically speaking, and also got a lot of attention because the Supreme Court refused to acknowledge and say that a misdemeanor, aka the exact same reason we just saw a man murdered on all of our television screens, and the Supreme Court refused and said, no, we're gonna make sure it's a case by case basis. So what does that mean for Mr. Lange or for other people like Mr. Floyd?
You have to go to trial and tell somebody that you were violating.
Victoria?
I feel like they were basically trying to like make it so that people can't use it as like an argument in support of the George Floyd.
Boom. Because if it's a case by case determination, they refuse to set a very firm rule that says, okay, felony exigent, yes, because we have a substantial government interest, but misdemeanor, no. There's a reason we don't punish these as seriously, so you're not allowed to hot pursuit. So, but they conveniently said no and said, we're gonna make it a case by case basis. Everyone should be a case by case basis. And I think Lorena and I think Ellie are right. We're trying to cover our ass. We're concerned, and we want to make sure that if there are anything in the future, issues like a George Floyd case where an officer was following in the pursuit of a misdemeanor and something were to happen, as long as this is the standard, what is the police officer protected from?
That bullshit immunity.
Because there's a very obvious rule that says you can't pursue an individual in exigent circumstances for a misdemeanor. Would they be covered by qualified immunity,
No,
even on a case by case basis?
no.
Absolutely not. But do they get covered by qualified immunity on a case by case basis if the rule doesn't exist?
Yeah.
Because we can always justify during the fact or during the course of an interaction what may or may not have made the police act that way. It's going to
I have a question about, okay, so what if, police were trying to pull somebody over and now what other day, what they had like some type of disability and they just simply didn't hear them? What, I mean, I know that it's a crime to not pull over for the police, but what if, somebody just didn't hear them?
I think this would go to the case by case basis, and then the judge, they would have to, like Ellie said, we would have to literally take everything to trial then, because now we're gonna have to figure out in every single situation, a judge is gonna have to be the determination of that fact, did someone hear or not hear? And then it was probably going to be on the defendant to say, like, I have a hearing aid, or, it was nighttime and I didn't see, and then the judge is gonna have to determine who they believed. And who do you think a judge is gonna believe when, by the way, if we're testifying again, this won't be a full trial because we'll have the evidentiary hearing first. But let's say we're at the evidentiary hearing and the police and the individual who's accused of fleeing have testified. Who do you think the judge is gonna give the benefit of the doubt to? 12. Yeah, right? So how do we ever get out of that?
Well, and technically, don't you have to get a hearing test when you get your license, and you have to be able
You
to
do.
prove that it's here.
You have to take a hearing when you get your license. You do?
Like,
You do.
redo
Yeah.
I was gonna say, but do you have to redo it?
No, but eventually if I like lost my hearing.
My grandmother, I've told you about my Nana, she's 90 years old, the one who refuses to wear sweatpants and instead wears skinny jeans and cuts off her circulation and passes out. That one. She still has her license. Exactly. I don't think that's a great idea. I wish my mom had taken it from her a long time ago. She won't do it.
She still driving.
She's still driving. My stepmom has a seizure disorder. It's not registered with the disabilities, so she doesn't have to give up her license.
That's dangerous.
That is very dangerous. Trust me, I've talked to her about that a million times. But are they allowed to do it?
Yeah.
Just like aren't, elderly people allowed to drive despite the fact that they may not be able to hear or see very well?
Unfortunately.
My mother-in-law still has a driver's license. She's legally blind. How did she get that? She is legally blind. Does not, I would be very clear, she does not own a car and she does not drive. Dr. McCuddy and I drive her everywhere. I would be very clear about that, but she still has her license.
If she got a car and like died and hit someone, could you sue somebody for like her?
Yeah, don't you have like some kind of responsibility to be
Well,
like a?
Dr. McCuddy does because he has power of attorney over her. I didn't sign anything, so I'm fine. Just kidding. No, especially if individuals are still capable of acting on their own, just because you have power of attorney doesn't mean someone else is automatically on the hook if you were to engage in anything. It's called tort liability. That doesn't necessarily transfer to you just because you have power of attorney. Especially because my mother-in-law is still an independent, able to like think, she's got power of attorney only for seeing issues and in case of emergencies. She doesn't have it in a situation where someone's deemed incompetent. Let's say someone was diagnosed with intellectual disability and they have a guardian, that person might be held liable for any torts committed on that person's behalf. But typically not, and the reason we don't do that is, what if you, as a child, were to go and cause thousands of dollars worth of damage to someone's property? Are your parents responsible for that?
Yeah.
Are they?
No, because the person suing the one who vandalized the property or did damage.
And can you sue a child? You cannot. No. They can try to sue your parents in court, and a lot of times in civil court, a judge might just be like, I think it's fair for you to pay to have it fixed. But can they get like lost wages or something from you? No, you're not gonna get that, because if the person who committed your tort was a child. We don't think children have tort liability. Great, any other questions? We're gonna talk through some of the questions on the midterm next, unless we have any more questions about range.
What did you decide we do if we miss when we're talking about the June?
I am going to go over all but one essay, and I'm going to determine that on Wednesday when we're done. And then whatever that essay is, the people who have missed should write that essay, but it's mostly just for credit. So just write me an essay.
Will you put it on campus?
Yes, I will. All right, any other questions like I said about lanes before we talk and go through the midterm? All right. All right, for those of you who have your computers or devices with you, you can pull up to, I just made the midterm viewable so that you can look through it. So the first part that we're going to go through are some hypotheticals. These are the most common type of like short answer questions that you'll get in law school. It essentially lays out a fact pattern. And then I ask you, based on the fact pattern and what you know about law in that particular area, what you think the outcome will be. So let's go through some of these together and you guys tell me what you think. Hypothetical number 1, Memphis City School students collaborate and create a student-run Black Student Lives Matter organizations to advocate for the rights. What?
Where is this?
If you go into either assignments or in modules, it should be down at the very bottom on exams. If you're
It's not.
Oh, wait, no, it's exams is at the very, oh, yeah, that's blank, so actually.
Yeah, it's not on there.
why is it? It should be just, it should look.
There's a spot for exams, but there's nothing over.
All right, well, follow along with me on the board until I'll fix this for the next class, I promise. Memphis City's school students collaborate and run a student-run Black Lives Matter organizations to advocate for the rights of students of color and other vulnerable student populations. These students plan a demonstration by wearing a t-shirt that says "Stop Killing Us" to school. The school board is notified of the plan and intends to support the student demonstration, provided no school rules or policies are violated. The Parent-Teacher Association demands that the school act against the demonstration, citing safety concerns, among other things. The PTA requests an injunction in federal court prohibiting the school from promoting the inappropriate speech at school. The school defends its position on the grounds of the students' First Amendment rights. With your knowledge of First Amendment case law, how might the Supreme Court decide this case? Be sure to include the legally relevant rules when making your argument. What case is this?
This is the one where.
It is close.
No,
Okay,
it's
Barn
the one
History.
where you can wear.
Yes, this is Tinker. And Hazelwood, which was the other one. Good job, guys. What are our standards there? Yes, students don't shed. So we know we have them. What are the legally relevant facts in here that I've included for you so that you know whether this is going to be protected or not?
But if Thomas is gonna be on there, Thomas is gonna go against it.
We'll get to that. How might it turn out in a second, like current court? We'll get to that.
Public schools cannot censor speech unless it disrupts, education.
Unless disrupts.
And what is it when, like, if it's something that's pertinent to you, like, your peace out cut shirt, like, you know what I'm saying? You know what I'm talking about? Like, if it's pertinent to you.
Yeah.
You,
If it's like your personal,
like, your personal, like, experience.
Yeah.
That's like harboring the shirt.
yeah,
What is that?
I don't think there's a specific
Okay.
legal test that gets us, but typically if it's something that's happened to us specifically, like to compare Tinker to the thing that I have, what's different about the students in Tinker versus the students in this particular hypothetical?
The school support.
One, yes, school support, so this is different, we have differing factors, we would need to talk about that. Does that help us or hurt us here? Yes, why does it help us?
They're saying nothing's being disrupted. in the
Yes, they're supporting and saying, we have no disruption, what were you?
So you don't violate anything.
Yes, as long as we don't violate, Victoria.
I was gonna say what's different is like they were protesting the war in Vietnam.
Mhm.
They weren't in Vietnam.
Correct.
They weren't, like directly.
Yes, so what's true about this hypothetical? Huh?
And applies to their.
Yes, it's about their experience in the school, is it not? So it's not just saying, hey, we dislike what's happening at a national level, it's saying, hey, we dislike what's happening to us here in this school. So it's incredibly relevant. Because that was the issue in Hazelwood, right? They were writing about teenage pregnancies and divorce and stuff like that. In the school, and the students defended it and said, hey, this is what happens to us. Same thing. This is relevant to their person and their experiences. It's true to their experiences. Who else? Go ahead, Taylor.
I feel like it also includes the PTA, and I feel like the PTA is not gonna have much leg to stand on.
Yes,
It's not as.
it's not a government actor. Who gives a shit? You don't like it, parents, tough.
You can get shirts too.
Yeah, you can get shirts if you want because we don't like it.
Yeah.
Okay, go ahead, cool.
Don't use the PTA funds to pay for it.
Yeah, exactly. It's not a government actor. Also, do they have a substantial interest in preventing this from happening? No. No. And we don't have any legitimate pedagogical interests are disrupted? Or are you having your hand up? Bill, go ahead.
What's different between this hypothetical and the one that actually happened in this hypothetical? The school is actually hearing the voices of the students.
Yes.
And they are voicing the students' concerns through them.
Yes, so the school is actually acting as a bigger conduit and saying, like, we agree there are issues. We think the students should have the ability to talk. Tinker, that was not happening. So when we have the school support, we know we're not gonna have any disruptions, pedagogical disruptions. That's what we're talking about. So we're not gonna have these. So we're gonna have a different outcome, except for, as Taylor pointed out, the current court. Who's on the current court that might make this a bit of a problem?
Well, would it even ever make it to the Supreme Court? Because I don't understand what.
No, 4 people would need to vote to that the Supreme Court said. No, this is just purely speculation. Thomas is on there. Who else is on there? Who doesn't believe children have rights? Which is interesting because she certainly believes fetuses have a right.
We can talk about later, like.
Yes, we can. We'll talk about it. We'll talk about Alabama, all right?
Are we gonna talk about, putting on Instagram that I sent you?
I don't know, because I don't remember which one you're talking about this moment. All right. Everyone understand how this hypothetical comes out differently? And in your, so in an exam question that asks this is what I would say. I wouldn't say, you say, hey, this is Tinker and Hazelwood. Except the difference is so we know that we don't shed our students don't shed their rights. So generally they're going to be protected unless they were disrupting. However, we know here that school is supporting them. This is relevant to the students' experiences and therefore is not going to disrupt any pedagogical interest. Also, the PTA is not a government actor, so we don't really care what they have to say if the school supports it. We might then at the very end discuss, like, we think this is what's going to happen. However, the current court is predominantly conservative. When we say conservative, we mean originalist interpretation. We don't mean Republican. And originalist interpretations, did children have rights in the 1700s? No, they didn't. So Thomas is actually kind of right about that, at least as far as it being an original intent argument. And then there are several more justices that have been added. Kavanaugh would be one of them, and then Gorsuch. So yeah, wouldn't look great for us, right? No, probably not. All right, good job. Next one. Huh? Yeah, the next one definitely is probably the most likely to happen.
Okay, not the slur. No, not with them.
You don't think I would use a slur about Steph Curry? You are wrong.
No, I don't think a racial, ethnic, or
A racial one, but would I make a slur about Steph Curry generally?
That's gonna be Professor MK.
Yeah, Professor MK, this is me. I did it. I'm telling on myself. No one, please go into your other classes and say I talk shit about other professors. I'm talking about myself. Professor MK uses derogatory racial, ethnic, and gender slurs during their class after being extremely upset at the Grizzlies' loss to the Warriors. Yeah, that sounds about right. Gonna go full Draymond Green on everybody. Their students report this to the university. The university officials reprimand Professor Webb and explain that they cannot use inflammatory or derogatory words in class. Professor MK sues the university for violating their First Amendment rights, ignoring any university policies or contracts. So please do not bring up university policies or rules or the fact that the person would have a contract at this time. And knowing only what you know about the First Amendment, how might a court decide this case? Explain the legally relevant rules when making your argument. So what is this case? What's our precedent? What have we read?
Cohen? That's the one where we talked about circling back, strong feeling on a personal experience.
His strong feelings on a personal experience.
Protection of emotional speech.
What was it?
Oh, yeah, fuck the drama.
Right? This might also be Bong Hits for Jesus could also come in here. I can't remember what the name of that case ever is. All I know is this is the Bong Hits for Jesus case.
Oh, Morris v. Frederick.
There we go, Morris.
Frederick.
We know what it is. We know it's the Bong Hits for Jesus. Taylor, go ahead.
So it doesn't really explain who you're using the derogatory terms to, or are you just talking out loud, or are you writing it with somebody?
That's a legally relevant fact. Gracie. Oh.
The academic freedom, that's your concept.
So these are some distinguishing features. Yes. Go on. Okay.
Slurs are fine words.
Yeah.
I mean, I don't, I think they are.
And it doesn't appeal to the Puritans.
Purient.
Lapse.
So would anyone, how many of you would consider me referring to a member of any person that you knew by a racial slur to be fighting words?
Yeah.
If you don't, if it's Clay Thompson's ass, no one really cares, right?
Oh, I don't care.
Oh, Ellie, get better taste in that. Just kidding. I'm just kidding. Huh? We're not shaming Ellie in class. We're not shaming Ellie in class. That is not what we're doing. We might shame NBA players, but we're not going to shame Ellie. All right. But fighting words, would we consider fighting? What would we consider it to be under the category of fighting words?
Racial slurs.
Yep.
Threats.
Yep.
Profanity.
Potentially. Now. So we know that fighting words, are they protected or not protected by the First Amendment? Not. So what about my suit? What's going to happen?
No.
Exactly. It's not going to go forward. Why? What about the, as Gracie brought up, academic freedom?
That has nothing to do with
Yeah,
academia. And you don't have tenure, so you're not protected.
Again, ignoring contracts, ignoring the contract and university system.
I know we're ignoring the contract, but are we still taking into account that you teach criminal justice and not like something related?
We're taking into account the fact that I teach. Where do I teach? At a public university. Am I a state actor?
Yes.
Yes, I am.
But our ages also come into play, because like we're not, minors.
Absolutely. Absolutely. So especially like if I were, like previously when I wore my shirt that had some expletives on it, and I wore that, I'm obviously going to get away with that more in this class or more on this campus because you are all adults. You can watch things that are rated R by yourselves. If I were to wear that on even a high school campus, would that likely have gone with First Amendment protections? No, why not? Different context, right? And would it have disrupted the legitimate pedagogical interest in a high school?
Yeah.
Yes.
You're all over 18, you can see a cartoon drawing of a uterus and see the word cunt and be like, ha, funny, and move on. Do you think that 13 and 14-year-old boys can do that?
Absolutely not.
They can't even look at your shoulders, apparently, without having thoughts of chaos. So who knows what they would have done with that shirt? So that's, again, a situation is always gonna matter, but ultimately, because remember, Cohen was in a courthouse, right? And he took the jacket off. And Bond for Jesus again at a school. So those things all do matter, but again, we're at a public university. And academic freedom does not cover fighting words. Does not cover fighting words. Not protected. Fighting words generally are not protected. So the second you start making them, you've lost your First Amendment protection. That make sense? Everybody understand? Questions? Great. Down with you. Next one. Yes.
What if you weren't directing it or saying it to us, but you're kind of mumbling it to yourself, and then a student came in and they would want me to go off and kind of explain.
Then it would depend. If I was not necessarily speaking it to anyone, probably still be a problem because I'm still one in my classroom. I'm still in front of students. They still have the ability to hear me. It's not like I was, talking in a private situation and someone just happened to hear me. So as opposed to like the Fourth Amendment, plain feel or plain hearing, not necessarily plain hearing. I was still in class.
What if somebody's got their ear to your off store and they-
Oh, I feel like you're a little.
I need a fan. Does anyone have a fan? So would that be protected? Absolutely, because you were in private. That's your private right. That's me.
This might be like a slow question, but like. Do you like, I know we're not doing like university policies or anything, but like. As a professor, do you have your own, can you teach the way you want to teach?
Yes,
Okay, so,
generally speaking.
like now taking it out of this like specific scenario.
Mhm.
What if you were just like using all those cuss words and profanity, like.
As like an example.
Yeah,
Mhm.
like, cause I mean, I've had professors like that in the past.
Yeah, for sure.
Like Dr. Gurley, when I had him, like, he
Oh,
was
very-
very.
Yeah.
So fun fact, this example was actually written when that happened. And that is why I used it, because everyone, and all the students in class had asked me and were asking generally. And so instead of answering the question, I put it on the exam to let them answer it. What happens in those situations is, it depends. And in situations where there is a complaint, and there are multiple complaints about how individuals engage in their classroom, and to the level that it makes a student feel unsafe, then that individual's, again, we're going back into fighting words territory, because if an individual feels unsafe, whether or not you were using it in a way that was pointed, or whether or not you were just generally using it over and over and over and over again for reasons that no one understands, you still made someone feel unsafe, and as a professor, you cannot do that. That's still fighting words.
He just came up to mine, and I took him like freshman year, it's like a long time ago.
This exam question was written for Dr. Gurley. Shout out to you, Dr. Gurley. All right. But yeah, so that's one of the, I know.
He said it.
Yeah, he told me yesterday. But I don't know what that means. He's actually sick. He planned that illness.
Oh, no, he's actually.
I do believe him. I believe him.
And even if he's not, he's sick.
Exactly. Even if it's not, guys, do I ever care why you miss class? No, I do not. I give you a like and tell you to give me an eye regret. Have a great day. All right, next one. A military veteran develops an addiction to certain medications after experiencing several traumas in the service of his country. He is unfortunately arrested, prosecuted, and found guilty of possession of narcotics, a Class E felony, in his home state. He has successfully completes probation with no issues and even maintains his sobriety. He moves to a new neighborhood, which is known for high crime. He feels it necessary for his safety to continue carrying a firearm on his person. During a traffic stop, an officer asks if he has any weapons on him. The veteran complies with this question and says that he does. The officer runs his name and discovers that he is a convicted felon. He arrests him for being a felon in possession of a firearm, and he is found guilty. The veteran and his legal team challenge this as a Second Amendment violation. With your knowledge of Second Amendment case law, how might the Supreme Court decide this case? Which is actually pretty funny, because I wrote this question before Rahimi, the case that we all discussed. We didn't read it, but we discussed it because it was recently decided by the Supreme Court. I wrote this exam question before Rahim came out, so knowing now what we do about the Second Amendment, and with the current challenge to the Supreme Court being specifically about a DV issue and not drugs, what do we think, or what's at play here?
I mean, he's still a felon in possession of a weapon.
He's still a felon in possession of a weapon. But what do we know about the Second Amendment right?
He has exceptions.
As exceptions. So we're of course going to be talking about the second. Exceptions. What's our case law? Yeah, there we go. Heller and McDonald. What's the rule? Does the right to bear arms exist independent of the militia?
Yeah.
Yes. So what bearing is it then that he is a retired, or he is a former service person?
It means.
Absolutely. That was just thrown in there to throw everybody off. Just in to throw everybody off. It also is pretty much the exact same facts as Heller, but with a drug addiction. And Rahim is going to take up whether or not having any or essentially non-violent non-conviction can be registered. So this would be a non-violent conviction. So this is a more, I guess, interesting question. So we pretty much know how the court's going to come down on this one, right? What is that?
I'm gonna say he's a felon.
And a felon is a long recognized exception. In fact, when did we start recognizing it?
Much longer. In the 1800s.
Absolutely, with the 13th Amendment, did we not? So it does make this a little bit interesting. This is a quick side note. Taylor, I see your hand. I'll get you in just a second. Typically, the Supreme Court conservatives hate the 13th, 14th, and 15th Amendments, not because they gave individuals freedom, but because they created the issue of incorporation, which conservatives do not like. They don't want them to apply to the states. But conveniently, in the Second Amendment, we've done so, haven't we? We've also incorporated one of the longest recognized exceptions in the 13th Amendment. So if this case were to come up in front of the Supreme Court now, how do we think they might decide it? That might be a more interesting part of this question. You think they would say the same?
They might take into consideration that he's not a violent felon, but I still think, I mean, it's been.
What's the difference between this versus Rahim?
Honestly, I think that they would leave it the same because it would be too much work to change it. Like if you change that, then you have to reevaluate so many other cases where felons were in possession of weapons.
Taylor,
Devil's advocate.
go ahead.
It's not easy, it's not violent, but you do mention him having a drug addiction after trauma. And most of us know military and PTSD. They're likely going to tell him not having any rights because they don't know it.
Absolutely, because what are other recognized exceptions?
Mental illness.
Deny someone for mental illness, right? And what was one of the arguments made in Rahim was that he had grown up in Afghanistan. He had a very different understanding, and that one of the reasons that they were arguing in Rahim, the new case that the Supreme Court's going to be taking up, is because of that experience of trauma, and he needs to feel safe. We've already seen one court already say that's not good enough. So I don't think the Supreme Court's going to make very much of that either. I think they're going to say, no, we don't really want that. And I think they'll actually go a little step further, kind of where Taylor was going, which is this person has PTSD. Do we want individuals who are suffering from PTSD to have firearms? I mean, some people do. Some people think it's a great idea. And some of us think that's a bad idea. Victoria.
I mean, like, sometimes like veterans with PTSD can't even like hear fire without feeling some sort of way.
Absolutely.
And like, how would that? I just feel like they would say no because they wouldn't want someone carrying, like, if you can't carry the gun and shooting.
Right.
Without like doing some sort of like overwhelming experience, how do you know you're not gonna go and like kind of go into like a breakdown and shoot people who you didn't mean to shoot or don't deserve to be shot, whatever?
Absolutely. Is there anyone who thinks the Supreme Court might, hearing a case like this, based on the fact that they are veterans, say, you know, people who have been formerly armed services or formerly police in the United States, we're gonna give them an exception because they've passed a background check since then?
Depends on the justice.
I think you're right, actually.
Definitely.
Michaela says depends on the justice. Do we think anybody else might take that issue and say like, well, people who have been thoroughly vetted by both the military and police agencies, we're gonna trust them. They can have it even after they've had a conviction. Because can you be a felon and serve as a police officer? Oh, yes, you can.
Can you really? Of course. What? You don't know.
You can in Memphis Police and Memphis Police Department. Yeah, they changed that law several years ago. Why did they have to change that law?
They couldn't get anybody to work for us.
Couldn't get anyone to work for them. Correct. So now you can have a felony. It has to be a nonviolent felony. It has to be within so many years old, and there has to be stipulation. So I'm not saying people who have like a murder can go like jump on the police force, but I am saying you can have a felony and serve on the police force. Yes, Lorena.
In a sense, yes, I mean, it's like justice, we talked about before, before the oranges.
Yeah.
Constitution. You know, during that time frame, they hadn't really, they knew, but people were not very, like, we're into like reality. Not really into, like, mental health and how
Absolutely.
cause someone to really be sort of lucid. I feel like in a sense, they could side with them and feel some type of.
I think so too. I think so too, especially because they've said that the right does exist independent of the militia. But this is someone who isn't independent of the militia. This is someone who's actively part of the militia. So they might say, hey, he's even considered in the clause that we had previously considered it was prefatory, and now it matters again. So we're going to say he was a part of the militia, so even more he can have a gun. I think there's a possibility that it could go that way, depending on, but the court we're currently in front of, who knows? I don't know how Raheem's going to come down. And that's just with that's with a DV. And that was with no conviction whatsoever. This is a drug conviction, and we're moving generally also recognize that even though we have a pretty much more conservative court, a lot of times the court will take into consideration global movements or big social movements. And do we have a big social movement regarding drugs in this country right now?
Yes.
For legalization and to generally expunge the records where you have no other felonies except for drugs? Yes. So the court might take that into consideration and say, you know, all 50 states are doing this now, or, you know, 40 out of the 50 states are doing this now. So if they're going to do it, then we're going to allow it. So just things to think about more for the second part, because that first part was pretty easy. The Second Amendment is always pretty easy. Next one. Fourth. An off-duty security guard for a private school discovers a person roaming in the parking lot after hours. He observes the individual trying to open the door handles of several cars in the lot. The guard calls 911 and reports these observations. Officers arrive to the scene and observe an individual in the lot. They stop this person and ask to speak with them. The person refuses. The police officers demand that the individual stop and be subjected to a pat-down search of their outer clothing. The officers discover marijuana in a cigarette package, and the individual is arrested and charged with possession. The defendant challenges the search. Knowing what you know about the Fourth Amendment, what arguments can be made that it is constitutional and what arguments can be made that it's unconstitutional? And how do we think the courts will decide? So here's the argument that it's was a good search or a good arrest. And here are the arguments that it's bad. Somebody tell me what we're talking about.
What's the one where, I can't remember the name of this one, but it's something you can only feel it. And I remember you specifically saying something about if you feel a cigarette packet, you can't make a determination about what's inside.
That's plain feel. So do we think that means it's a good search or a bad search? Why is it bad? So this is plain feel. And what is true about plain feel? I see Victoria and Taylor. Do either of you know what I was going to say about plain feel?
No.
Yes, correct.
And I was gonna say, like, also, If it was the security guard for the private school, then it would be a good search, because it's not government actors. But since he called the actual police, then that takes a whole other step back to count.
So this might be kind of like what we might call an anonymous 911 call, right? Essentially, because he's not related in any other shape, form, or factor, he's just a random person calling in, right? To report. So what's true about an anonymous 911 call? Can it be used to stop and search a person?
Well,
That's Florida versus jail. What did they need to do?
What is it themselves?
Find corroborating evidence. So something to corroborate, did they?
no. But given the fact that it's a school and everything that has been going on lately, doesn't that totally?
Does it?
After hours, students can still be on the property.
So these are great factors that might go into what?
Dissent.
No. But. You do it that really, yes, go ahead, Tracy.
But it says that when the officer arrives and he observed an individual himself to see if it's not happening.
So, yes, he corroborated, so that would put us back on good search side. It is an anonymous, essentially treated like anonymous 911 call. He did get information. They arrived to the scene. If they had not done any observation and just immediately walked up to the first person they saw and started to pat them down, it would definitely be in bad search. But because he arrives and starts to observe and corroborates and starts to talk to anybody, we're back over here in good search land. Joshua.
Well, if I went back into bad search, because it wasn't a resident, I think they still searched them.
So this is a stop. What can you do? What do you need it to stop? Oh, Lorena, go ahead. What do you need it to stop? To stop someone? What did we have to suggest that there was reasonable suspicion here?
A 911 call.
What else?
The doors.
He's on a school campus.
It's a private school. too, so
Uh-huh.
that'd be-
Yep. What else? Night? Can your refusal ever be used to create reasonable suspicion?
Not on paper.
Not on paper. Great answer. So we might put refusal. But does all this make it a bad search or does that make it a good search?
Makes it a great search.
Makes it a great search.
Greg.
Great, you're right.
Great, not great.
Great is a strong one, but okay. Yes, it makes it a great stop. What's then the problem with the stop? We get back up here. Playing field. Too manipulated.
Doesn't say it smells weird.
Right. Which would go to the lack of. No smell.
Does them taking out like the cigarette pack and looking inside of it, does that even fall under the umbrella of the pat down?
Yes, it falls under the umbrella of the pat down, but once they've gone inside the clothes, are they still in pat down territory?
Right.
No, they're fully in search territory. And can you do that
No.
based on what they know? No. So parts of this search are good and would be upheld. Parts of this search are bad and would not be. What ultimately happens?
They threw out the marijuana
Why?
because it was obtained via an unlawful search.
And anything obtained from a non-lawful search must be excluded because it is what?
Fruit of the poisonous tree.
Boom, so proud of you guys. That was great. Great. And how do you think the current court would come down on this particular search?
They came down on Riley. I mean, yeah, Riley. They wanna
You think?
uphold anything that's a violation of your amendment right.
You think?
Yeah, no exceptions.
Hmm?
No exceptions.
You think you don't think the court might be swayed and say that the officer had every reason to stop and do a little bit more than a pat down? That he had probable cause to believe that a crime was committed or being committed because of they pulling on the door handles?
Well, I think, what's the question?
And the trespass?
I think the stopping, the questioning, the pat down is all legal until you get to the removal of the cigarette packet. So I think then the court would say,
So what's one of the doctrines that would have gotten it in anyway?
case by case.
Well, range, yes, and a case by case basis. What else?
Oh, the thing about officer protection?
No.
No, okay. Where the Sean?
I feel like Andy's got it and just on the tip of her tongue. Victoria.
I mean, they could have said that like officers have the totality of circumstances.
They could have said, I think they could make a pretty reasonable argument that they actually had probable cause to conduct a search. Based on the fact that they believed him to be involved in, one, they caught him trespassing, this is private property. And you could have arrested that individual for trespass, which means that you could have performed a search incident to lawful arrest. And this would have been inevitably discovered. I believe that the court would have found this was inevitably discovered. Victoria.
Is this part of like maybe specifically in Memphis, could they use the fact that we have so many like car break-ins?
100%. That would absolutely go into it.
Would
in
that
here.
fall under police totality?
Yes, absolutely would fall under totality of circumstances, known high crime with respect to a specific incident. And this was car related theft. And we know that that's experiencing, and we know that's happening a lot. We know it's happening a lot in this particular era. That can absolutely be used for a police's totality of circumstances. If they were told perhaps that a particular jurisdiction or their patrol area, what are they called? Oh my God. Districts, thank you. Why was that so hard? Districts, their particular district is struggling with this particular type of crime, that can absolutely be used to create totality of circumstances, enough evidence and totality of circumstances. So I want to see you discuss both of them back and forth. First and foremost, we need to discuss we have not a government actor. We need to discuss that this is essentially akin to a 911 call. We have some corroboration. We have some plain feel issues. We have some reasonable suspicion. So this would have needed to be a particularly long essay or a fact pattern, or excuse me, a fact. How do we think the court would come down on it?
I think you're right, I think inevitably discovery would have been, especially since he was already like yanking on the door handles and stuff, and
If he's already yanking on,
he wasn't just there, he was doing something.
And then
Can't use that against.
you can't use your refusal against somebody on paper. But do you think those justices hearing this case are gonna think very kindly about that refusal?
Well, would they even get that information?
Yes,
Why?
it would be in the record.
Why?
It's in the police report.
Why can you put that on paper if it's not supposed to go against you?
It's just a fact. Lorena.
Why would it be to do so? If it's not for profit? Having to make it so and they were refusing to like explain why they were there. Or whether they actually went to that school, didn't go to that school.
So they refuse to talk to police. Are you allowed to refuse to talk to police?
Yeah.
You're allowed to refuse.
Oh, okay, I thought you were talking to the officers.
Yeah. So no, there's refusing to stop to the office or stop talking to the officer. They stop and ask to speak. If an officer asks to speak with you, you always have the right of refusal. They know. The second time they say, no, you have to, and he stays. So again, one of those things on paper, you can use against them, but are not on paper. You can note it on paper. It will go into the police report that you refused. Absolutely. Gracie.
So they say that again and they demand your side. No. Wow.
They're probably gonna arrest you at that point.
But then you still have to talk to them.
Correct. That's when we're getting to in the fifth amendment. We'll get to that after spring break.
Okay.
Any other questions about this one? Feel like we understand that one. All right. Is 5 the last one? Yes, 5 is the last one. All right. I'm involved in an undercover investigation for narcotics. Who's surprised by that information? Very probable, very probable. All right. Police officers in an undercover narcotics task force conduct an investigation on Professor MK. Before the investigation can be completed, we're not done with it. And warrant request presented to a magistrate. So before that happens, Professor MK is arrested out of protest for capital punishment. Also tracks. On their person, Professor MK has a backpack containing a tablet, phone, notebook, and other items. The officers peruse the notebook to locate passwords on the devices. The officers then log or open and go through the devices to look for evidence related to their narcotics investigation. While doing so, they discover Professor MK is part of a high-level plot to overthrow the government. Part of a coup. They arrest them and prosecute them for conspiracy to commit terroristic activity. Professor MK challenges the search and seizure. Using what we know about the Fourth Amendment, what are the arguments that it's a good search? I'm gonna put that up here. What are the arguments that it's a bad search?
This Friday.
This is Riley. But what's different? So we know Riley's at play.
Did all your passwords are written down?
Yes, this was password protected, so is
It's
that help
extra
or
privacy,
help or hurt?
bad. You were arrested.
Also, what was your crimes? No, initial crime, what you got them to your notebook?
Probably trying to find you.
How's that protest?
She was staying in the street.
Yeah, I wasn't moving enough. Victoria.
So like, I'm confused because it says you were arrested on the protest for California.
Yes.
Where you arrested because you weren't.
Assume the arrest is lawful.
Okay, that changes.
Assume the arrest is lawful. I love that you guys were questioning that. That's great.
You had all your stuff written down in the notebook, but it's like, I mean, it still has a password on it, so the intention to protect the information on there is.
Why are you carrying?
But yeah, I was gonna say, why do you mark that? Okay, grandma.
I took a page from Dr. McCuddy.
He would put his in his Chromebook.
It still doesn't give them. Do they need a warrant to first search that notebook?
Do they?
Do they, given the fact that you're already under arrest?
What does that change?
And, well, don't they have to prove that whatever, that it's viable that you were further commissioning crimes through your tablet? Like drug dealers, you can get a warrant to search their phone because it's probable that they're facilitating their crime through their phone, but
100.
what do you, what, 100?
Yeah.
Yeah, what are you facilitating through your notebook or phone?
You don't think I could be a drug dealer through my phone?
You
How do you
could,
think
but
people do drugs?
but they have no reason to suspect that, you're on a protest.
No. Remember, I'm a part of a narcotics investigation, undercover narcotics investigation.
So they know that when you're
Yes,
arrested.
I know that when I'm arrested.
Okay.
That I'm a part of that. So
Oh.
they're just like, they luck upon me at the protest doing something I wasn't supposed to. And they're like, haha, we win. We don't need that warrant. Conduct a lawful arrest. What does that give them ability to do?
Search.
And what else? And what else? Not just me, but
But
Victoria.
My thing, okay, it says that they didn't have a warrant.
Correct.
Right? So like, they didn't have a warrant on their phone. And then
Correct.
on top of that, you arrested at a protest, but they're looking for evidence for narcotics.
Correct.
So that wouldn't be inevitably discovered under the arrest at the protest that you were involved in narcotics or terrorist activity.
But at the same time, we don't know why you got arrested. It could very well have a good reason to go to the phone. Right?
I would make that argument that that would have.
What about, what did Riley tell us? What is unique about a phone and then, and the tablet? So did the officers need to get a warrant before searching those things?
yeah.
For sure. What keeps them kind of safe?
Passwords.
Inevitable discovery will always fuck you.
Especially since they already knew you when they already had a pending narcotics task.
Because what would that be? Might that not also be a little bit of good faith? An inevitable discovery? They were working on it. They would have gotten it anyway. They would have gotten a warrant eventually. We were almost there. They were already a person of interest. Right? Go ahead, Gracie.
They were already conducting an investigation.
Absolutely.
Their eyes on me and knew all the information, on the negative warrant.
Just didn't ran out of time before this incident happened. That's all.
Like, I was saying before the incident, they're like, why couldn't they bring? They know they're going to crazy.
So I think we're making some assumptions that, we can't necessarily make, so, this is envisioning a circumstance in which, police, not the same officers that are involved in the narcotics investigation, they're on the same police force. I get arrested at a different time. This happens actually pretty commonly. Where people are being investigated, but then they get picked up on outstanding warrants somewhere else. So this is kind of like that situation. I hope that helps answer or clarify.
Yeah,
some-
I was saying.
Yeah. It would be if they knew like where I was and they were going to get me, and you're like, why not just get a warrant for going to go get her? In that situation, 100% you're right. In this particular situation, this happens very commonly when like someone's known to police or they are being investigated, that they might get picked up on a traffic stop somewhere else and a warrant run for their name and get arrested for that reason. It's kind of mimicking that circumstance. That good faith one where we called in to see if there was a warrant and we found out, oops, sorry, that one was a bad warrant. What if that had happened here? What if the warrant had been issued but it wasn't the narcotics investigation that arrested, I was still arrested at the protest, but there was a warrant that was issued for me. Unrelated to this incident.
I mean, it's still a warrant. So you still have to come in.
But does it change knowing what's in my phone or my tablet?
Well, it depends on what the warrant covered. Was it just an arrest for you?
It's an arrest warrant. Only covers me.
No.
And we're still back at Riley. Still need it for the phone and the tablet. Seeing a lot more confused faces on this one than last time.
Well, what about the notebook then? Like, your notebook is just an extension of you? So they go through your notebook. If you write down your plan, they just.
If I had written all my plans for Doom out in an open notebook that I just put in my backpack and I was lawfully arrested, yes, they could go through that.
What if you got a lock?
If I had a lock on my notebook, could they open the lock?
No.
No. Because why?
Because you went through privacy, or.
It is. So, and also, correct, I have a higher level of expectation of privacy. Why else? What's the easy logistic reason?
You don't have a key.
Right? I don't have the key. I can't destroy the evidence that's in there. What's stopping them from just taking it into evidence and getting a warrant to read it?
Nothing.
Exactly, nothing but time. So that's why no one's gonna, no, we're not gonna, that's not gonna fly if it's locked. That was a great question though. But if it's not locked and I just got it written in there like some college notebook, you know, with the rest of my notes. Totally game, because it's search incident to a lawful arrest.
And they can take your passwords and put them in your devices.
Oh, no, that's when they've gone a step further. They're outside the scope.
They can just.
Because you can take what's in the notebook and getting what's on the phone, getting what's in the devices from the notebook is going outside the scope
But you can use
of the
something
lawful
you
arrest.
read in the notebook, in your warrant. as a
Correct.
reason too. Okay.
Absolutely, you
What
can
if you
use
don't
what
have
you
a
found
password?
there.
What about on my password on my phone? Still saying privacy or no?
Then we're right back at Riley. And can you go into a phone even if it's not password protected and if it's search incident, even if you're searching an incident to a lawful arrest? No, you cannot. No, you cannot. You need a warrant. There's too much.
What happens if they have your phone and you get like a text from your dealer or something and they see that text?
That's a great question. What do we think the Supreme Court would say about that?
I know what they do say now because I know that they will use that against you. Like if they have your phone in possession and as text comes up, it's like, oh.
What will be the legal doctrine that they use?
But at the same time, is it not expecting privacy because it's a conversation that is not meant for you?
Inevitably just.
But it really is you.
Plain view, if they legally have your phone because you've been arrested, you've been legally seized, and it just pops up, that doesn't give them the right to go into the phone and figure out what the rest of the message says or anything like that. But if they just see it and it says, hey, don't get caught with all the weed in the car, and that's what they see, that gives the police enough to go through it. It popped up on the phone. They didn't do anything. They didn't manipulate anything. Wherever that went a few minutes ago, they didn't manipulate anything to make that happen. They had a legal right to be there. That's what plain view and plain feel are about. You have a legal right to be where you are, and the police didn't do anything to cause that information to come to them, they're fine.
Your time's up.
Thank you so much. I knew that was happening soon, just making sure we're all good. Wednesday, we are gonna meet virtually. So see you all on your computers. We're gonna go through the essays together. And then I will leave one for people to write who did not come to either, so they can make up their discussion point.
And what are you looking forward to?
I'll put it in the rubric. Got it?
Yeah.
See you all on camera on Wednesday, virtual, please.